Day by day, implementation of mediation pre-court proceedings is expanding in Turkey. Becoming mandatory for several fields certainly answers the question why mediation has become a topic of discussion recently in the Turkish legal system. From 2019, this also became mandatory for IP-related monetary claims as well. Still, there is a gray area for implementation of mandatory mediation when monetary and non-monetary IP claims are requested together. My name is Güldeniz Doğan Alkan. I'm a litigator specialized in Turkish trademark law for 15 years. In this video, we will talk about the implementation and updates of mandatory mediation, especially in this controversial area under the guidance of recent court decisions. Mediation was incorporated for the first time into the Turkish legal system in 2013. In 2018, it became mandatory for some types of labor disputes, and at the beginning of 2019, it became a compulsory precondition to bring in commercial monetary claims before the courts where compensation or payment of a certain amount is requested. We need to admit that mediation is a rather new concept for Turkey, where we can say that the litigious culture is dominant. Statistics of 2019 and 2020 shared by the Ministry of Justice show that between 50 to 60% of the disputes were settled by mandatory mediation, depending on the dispute areas. Regarding IP disputes, mediation is mandatory when compensation or the payment of a certain amount is sought, such as disputes arising from the amount of license agreements, transfer of IP rights, or compensations due to infringements. But an implementation problem has emerged when monetary and non-monetary IP claims are requested together. Should we pass through mandatory mediation proceedings for all of the claims? Should we file separate actions for monetary and non-monetary claims to avoid the problem? Should the court enter into the merits of the case without passing through mandatory mediation at all? Thankfully, there are two recent decisions, one on trademarks and the other one on copyright matters from the Court of Cassation, guiding IP law practitioners on this matter. Both cases included infringement requests and compensation requests together in a single action. In both cases, the IP court and the Regional Court of Appeal ruled that the procedural law was violated and rejected the actions since the plaintiff did not apply to mediation first for this action that included monetary claims. So, the courts decided that the plaintiffs should have passed through mandatory mediation first, as foreseen by the law. In two separate decisions from June and November 2020, the Court of Cassation ruled on both of the cases that independent claims may be requested together if the competent court is the same. Mediation is not mandatory for cases where claims subject and not subject to mandatory mediation are filed together in a single case. Lower courts cannot rule for a lack of procedural step when monetary and non-monetary claims are filed together, and they must review the matter in its merits. Why these decisions are important? Because basically, many IP cases include monetary and non-monetary claims together, especially when an IP right infringement is at stake. So, this approach of the Court of Cassation is beneficial to the procedural economy principle. Bypassing the mediation procedure is favorable for the effectiveness of preliminary injunction requests as well. The Court of Cassation filled the legal gap regarding mandatory mediation for disputes containing both monetary and non-monetary claims combined together in a single case, and we expect to see more detailed and solid reasoning in its future decisions. If this approach will gain acceptance, we believe that a legislative amendment will become necessary to keep up with the case law and to fill the concerned gap by a legal provision. Beyond any doubt, we need to see more court decisions to say that we have an established, uncontroversial case law regarding mandatory mediation requirement when monetary and non-monetary claims are combined. This becomes more and more important considering that mediation is expected to become mandatory for other types of dispute. Well, we will see what will happen. You may find more details on this topic in our thought leadership paper for this year. Thank you for listening to me.